Welcome to the Truth About False Confessions podcast. I'm Alan Hirsch, chair of the Justice and Law Studies program at Williams College and an expert on false confessions. To learn more, visit my website, truthaboutfalseconfessions.com. Now on to today's episode. Although I am never allowed to testify whether a confession is true or false, naturally I ask myself that every case. More often than you might think, I cannot determine with any confidence whether I believe the defendant is guilty. That was definitely the situation in the first case in which I ever traveled to testify, the case that brought me to Charleston, South Carolina in December 2005. On the one hand, the murder weapon, a gun that indisputably fired the fatal shot, was found in the apartment of the defendant, whom I will call John Doe. On the other hand, the only evidence that Doe himself fired that shot were a shaky eyewitness and even shakier confession. In some important respects, the authorities themselves regarded the confession as false. Doe, while confessing in a statement typed up by the police and signed by him, named two accomplices whom they declined to charge. So too, Doe claimed that the shooting was accidental, but the state nevertheless charged him with deliberate homicide. The confession, which was recorded, followed an interrogation by 4 police officers in the wee hours. The police pulled Doe out of bed at 3:30 a.m. They offered no explanation for arresting him at such an ungodly hour rather than waiting until at least the breakfast hour. According to Doe, his interrogation lasted 3 to 4 hours, and he was under the influence of ecstasy at the time, which, granted, may have affected his ability to know how much time elapsed. The officers claimed the interrogation was much shorter, but they inexplicably failed to record the time that it started and ended, violating standard protocol. Along with the defense lawyer, whom I will call Mary Smith, I had previewed my testimony the night before I was to testify. I would explain at the outset that the ability to assess the defendant's confession was severely compromised by the failure of the police to videotape, audiotape, or transcribe the interrogation that preceded it. However, I knew from the police reports that the police had utilized the risky interrogation approach known as the Reed technique. As you may recall from previous episodes of this podcast, at the heart of the Reed technique is the combination of confrontation and minimization. In this case, the use of the Reed technique was obvious even without a recorded interrogation. One of the officers acknowledged confronting Doe with allegedly compelling evidence of his guilt while planting the idea that the killing may have been accidental, a common minimization theme. Doe's recollection, while understandably hazy given his drug use the night before, dovetailed with the officer's report. He maintained that he was threatened with the death penalty if he denied involvement in the shooting and was assured lenient treatment if he acknowledged accidentally shooting the victim. He insisted on his innocence for hours, despite the officers telling him they had an eyewitness and other foolproof evidence of his guilt. But he eventually broke down and acknowledged accidentally shooting the victim. Doe claimed that he confessed in part because he craved sleep and desperately wanted to go home. I also plan to testify that in a staggering number of cases of proven false confessions, after the fact, the defendant explained that he confessed because he was worn down and would have said anything because he just wanted to go home. Like John Doe, they often don't get to go home at all, not even briefly. After confessing, they are hauled off to a jail cell. I expected to explain all that to the jury, as well as the fact that teenagers are overrepresented in the population of false confessors. Doe was 18 at the time of the shooting. As I indicated, I also expected to testify about the inadequacy of the police documentation of the interrogation. Several reports mentioned that the police arrested the defendant in the morning without noting the specific time. Were they embarrassed to have dragged the defendant to the station at 3 a.m.? They likewise failed to record the time that the defendant signed the written confession, and the time he signed the form waiving his rights to silence and to an attorney. All of this, on top of the failure to record the interrogation, made it impossible to determine the length of time Doe was questioned before confessing, something he and the cops disagreed about. This is important because lengthy interrogations substantially increase the risk of a false confession. It was unclear, though, whether I would be allowed to testify about any of this. The prosecutor sought to have my testimony excluded on two grounds. One, jurors understand false confessions without the need of an expert, and two, the field of false confessions was insufficiently developed to justify expert testimony. The judge would rule on the state's motion following a hearing outside the presence of the jury. This is standard procedure. When defense attorneys offer expert testimony on confessions, prosecutors usually object. Most judges permit such testimony, but some do not. Before deciding, judges generally hold a hearing consisting of the expert being questioned by the defense attorney to show what he would testify to before the jury if permitted, and the prosecutor, aiming to show that such testimony would not be helpful. So as I sat outside the courtroom awaiting that hearing, I reviewed in my mind two different sets of questions and answers. First, Mary Smith would ask me about my background, particularly my experience in the field of false confessions, as well as the field more broadly. I would summarize the voluminous literature, emphasizing those parts of it relevant to the case at hand. Then I would apply this knowledge to the case, explaining problematic aspects of the interrogation of John Doe. On cross-examination, the prosecutor would try to show that relatively little is known about false confessions, and that the only thing I knew about this case was that I was getting paid handsomely. The judge would then rule on the admissibility of my testimony, which means either I would be sent home or, if the judge ruled in our favor, would sit tight and wait while the jury was summoned to hear me repeat everything I had just said outside of their presence. As I was reviewing all this on a bench just outside the courtroom, the door finally swung open and Mary Smith emerged. She looked at me with what seemed an odd mix of giddiness and anguish and uttered a single word: mistrial. When she got over her shock, she described the Perry Mason moment that had transpired inside the courtroom. The state's main witness, an eyewitness to the crime, testified that the lead investigator had held her in the interview room for 6 hours and threatened her with jail, thus coercing her into identifying John Doe as the shooter. She had actually not been close enough to recognize the shooter. As a result of that revelation, the judge declared a mistrial. End of case, at least for now. The prosecution might or might not be permitted to try the defendant again. That would be a subject of much litigation. But if the state was permitted to go forward again, they would have to do so without their lead witness. Mary had been confident that the judge would allow my testimony, and I had hoped to leave South Carolina having educated the jury and helped it reach a just decision. Instead, I headed home empty-handed. In fact, I left with less than I came with. Lulled into a false security by the balmy South Carolina climate, I inadvertently left my winter jacket in the hotel. But my trip was not a complete waste. When I left the courthouse, I strolled down the road to a nearby art museum. There, I encountered a spectacular work by 19th century American painter Eastman Johnson. Painted in 1860, the Freedom Ring depicts an African-American girl admiring the ring on her index finger. The painting refers to an actual event. Clergyman Henry Ward Beecher, brother of Harriet Beecher Stowe, brought to his church a young slave and asked the congregation to donate money to purchase her freedom. As legend has it, roughly $2,000 had been collected when one congregant removed from her finger a valuable ring and placed it in the collection basket. The slave, whose freedom the cash did indeed secure, was given the ring, and Beecher brought her to Johnson's studio for the artist to memorialize the event. Johnson portrays the girl as cherubic, but also imbued with adult-like dignity and a touch of sadness. The painting had special meaning to me at that time, because slavery was on my brain. I was writing a scholarly article about false confessions, subtitled Lessons of Slavery. The article revolved around something that seemed perverse. 19th century American courts were more sensitive to the risks of false confessions than courts in the 20th and 21st centuries. I argued that this apparent oddity stemmed from the earlier court's direct acquaintance with slavery and the well-known proclivity of slave owners to bully confessions out of slaves. I further argued that the psychologically coercive tactics used by law enforcement in modern America reduced suspects to a condition resembling slavery, fearful, desperate, and overwhelmed by ruthless authority figures. But back to the case of John Doe that brought me to South Carolina in the first place. Over the years, yes, years, Mary Smith kept me abreast of developments in the case. While the question of whether the state could retry John Doe slowly wound its way through the courts, it was discovered that the detective who allegedly manufactured eyewitness testimony against Doe had forged the identification of a suspect in an unrelated case. The detective was suspended from the police force and criminally charged. In the meantime, Mary located another supposed prosecution witness against Doe, who told her that he had been coerced by the same detective into making a false accusation. 2 years after the original trial, Mary emailed me that John remains in jail, he is slowly going crazy, the whole thing is a mess. A year later, she sent me her final update. John Doe was allowed to plead under Alford and was given 10 years. An Alford plea means that Doe maintained his innocence even while pleading guilty and accepting the consequences of a conviction. I am inclined to call it the Alford Ploy, because the defendant's insistence on innocence has no effect on the disposition of his case or anything else. Those who take an Alford plea are as guilty in the eyes of the law as those who admit guilt or are found guilty by a jury, and their conviction follows them around even when they complete their sentence and leave prison. The Alford plea or ploy seems like an empowering weapon for defendants, but it mostly serves to lure them into accepting the status of a criminal without the benefit of a trial. At best, it is a fig leaf. At worst, a source of tragic injustice. Thank you for listening to this episode of the Truth About False Confessions podcast. I would greatly appreciate it if you would rate the podcast on Apple, Spotify, or whichever platform you used to listen.